Thank you. You may approach and get situated. And before we get started, I'd like each of you to do a sound check with Justice Apple. He will be participating. When he speaks, then it goes to his face. This is the case of State versus Buelow. Mrs. Reinkoester, would you like to do a sound check quick? Your Honor, would you prefer I speak from here or here? Actually, you'll need to use that one for yours. If you would just do a sound check, please.
Sound check.
Very good, thank you.
Thank you. And now I will ask Mr. Fautsch. Yep, you will approach the center. That's correct.
Testing.
Yes, very good, thank you.
Thank you.
Thank you. Sorry for the situation, but it's working after that. Okay, Ms. Reinkoester, you may begin.
May it please the court. In Iowa Code Section 62210, the legislature provided a mechanism by which a criminal defendant may gain access to a victim's medical records in discovery. But the statute is silent on whether and how these records should be admitted as evidence at trial. The discovery protocol was initially laid out in Cashin, which was supplanted by a stricter protocol in 62210. But in Cashin, this court noted that the discovery protocol outlined in the case was meant only for the discovery of medical records, and stated that even if the records were permitted in discovery, that, quote, does not mean the victim's mental health records are admissible at trial. Whether the records meet the requirements for admission under our rules of evidence is a separate determination that the court will make at trial or in a ruling on a motion in limine. So today, we're here to talk about how our rules of evidence should apply in the admission of a victim's mental health records at a criminal trial. In contravention to how Iowa courts typically apply the rules of evidence, the Court of Appeals panel below created categorical rules for the admission of this evidence. The state does not believe that categorical rules should apply, and we'd urge that this court follow the Kansas Supreme Court's holdings in cases such as State v. CCAT in crafting a rule for the admission of this evidence. Now, in the state's briefing, we've discussed that there are three major rules at play here when discussing the admission of this evidence. And that is 401 relevance, 403, more prejudicial than probative, and the 404 character evidence rules. And we believe that the Kansas Supreme Court has found a good balance with these three rules in State v. CCAT, and that's based on their previous cases too in State v. DRAC, in determining when a victim's mental health records should be admitted at a trial. And that determination is part based on the timeliness component of the information and part on the prejudicial versus probative component of the information. And that's because the reason that this information could possibly be relevant at a criminal trial when we're talking about a suicide defense is we are trying to determine, or trying to determine as best we can, a victim's state of mind at the time that they died. Not at a time prior to that, but at a time that they died, what was the victim's state of mind? And so that's why the state believes that the timeliness component is so essential in determining whether or not these records are relevant to be admitted at trial.
So, counsel, we have some older cases that say the standard should be a reasonable time. And then the facts on some of these cases have found evidence of suicide going back 6 years to fall within the meaning of reasonable time. One, do you think 6 years is too long? And then two, if not, what is the standard for reasonable time?
So I don't know that you can, in all determinations when you're talking about relevance, it kind of depends on, I don't know that you can pick one particular time frame that is going to be, you can't pick like 1 year, 2 years, 3 years. It's not necessarily, it's going to be determinative on the facts of the case. But I think what you'll notice, or what I've noticed from the cases, is that part of the timeliness or part of the relevance component is not only timeliness, but pattern. And State v. Stanley, which is what the Iowa Court of Appeals relied on, when they made their determination, that was a case of pattern and not timeliness. That was a case where the victim was diagnosed as a schizophrenic and had an exact pattern that he followed every time, which is that he was hospitalized, medicated, got out of the hospital, stopped taking his medications. Then when he stopped taking his medications, he became suicidal and then attempted to commit suicide. And he had done this on so many previous occasions, this exact same pattern, that he was in the middle of that pattern when he died. He had gotten off his medications, and he then, died as a result of, he died.
So, counsel, are you saying we shouldn't be looking at time at all and just be looking for patterns?
I think you have to look at both. I think both are relevant in making the determination about whether or not that the information is probative of that particular victim's state of mind on the night that they died. So that's why I think Stanley, which is what the Court of Appeals used, is not really an appropriate standard to apply in all cases, because they focus mostly on pattern and not, timeliness. So I think there's a little bit of both in the analysis.
But doesn't it, how old, how dated the records are, just go to the weight? Shouldn't the jury evaluate? We're looking at July 2016, patient tearful, screaming, "I feel suicidal every day and no one will help me." That seems like highly relevant to a suicide defense.
So I think there's one very important thing that we have to keep in mind when we're making a determination about what the rules should be in the admission of this evidence. And that is, this is not just a typical piece of evidence. These medical records are constitutionally protected privacy rights of this victim. So, in many cases we could say, well, if it's just a standard piece of evidence, it would go to weight and not admissibility, and we should let the jury determine that. But here we have records that have a constitutional protection. So there needs to be a similar, threshold to making the determination about whether or not anyone should ever get to hear these records.
Under 403, it's a balancing test, of course. The first part of 403 is their relevance. And frankly, to me, it's hard to see that this isn't relevant. There might be a question of weight, but it seems to me it's tied to the defense that was offered. And then under 403, of course, we do the balancing, and whether it's outweighed by substantially outweighed by prejudice. So what's the argument that admission, at least some admission of the 2016 events, the prejudice would substantially outweigh its relevance?
So I think in this case, the district court didn't necessarily rely on prejudice when she made the 403 balancing.
No, the district court relied on character, and that strikes me as just not right. But there's still a 403 in the background. But why don't you take a shot at telling me it is character evidence, maybe?
Sure. I'll just say, first of all, I think the court did do a 403 analysis, but determined that it was, a confusion of the issue, not necessarily prejudice. In terms of character evidence, so when we're looking at applying these rules, the state sort of thinks that there should be an order. It should be 401, 404, and then ultimately 403. And so for character evidence, what I try to, assert in my brief is that the policy reasons behind why we have character evidence equally apply in this situation. And that is because we don't, as a policy, want to convict in the terms of a defendant, but also, in terms of victims. I can't think of the right word, but in terms of propensity, we don't want to make a determination of state of mind or state of action based solely on propensity evidence. And so that's what we see here, is that these records, because they are so remote in time, no longer are relevant to her state of mind, and so could only be used to show that she would have a propensity.
Was there any evidence to support what you just said? that it was so far back in time that it was irrelevant to what was going on?
So I think the victim's medical records in this particular case can, suffice for that, which is that if you look at her progress from the past year with her psychiatrist, her course was only improving. And she actually went to a psychiatry appointment the night before or the day before she died, in which her psychiatrist noted that she was not suicidal and that she was very low on the scale for depression and anxiety. And so he noted that she was actually in a very good mental state and that had been over the course of time, over the course of several months.
Counsel, though, in view of the defendant's due process rights to a fair trial amount of defense, we have to balance that in. And we have, in Iowa, a liberal standard for the admissibility of expert evidence. Shouldn't the jury have been allowed to hear the defense expert psychiatrist weigh in on how to interpret these records and how she was improving or whether her condition could be volatile and abruptly change?
So I would encourage this court to read Dr. Bean's testimony in the trial. It's not very long. He speaks quite extensively about the victims, that he reviewed her records and how he viewed the medications and symptomologies, in terms of, how that might have affected her behavior on the night that she died. So what we're saying is this kind of ties into a harmless error idea too, which is that the exclusion of this very limited amount of information, to begin with, does that necessitate a new trial in which a defendant got to present a very fully throated suicide defense in which he called 2 expert witnesses?
Wouldn't the testimony have been even stronger? I mean, Bean reviewed only medical records for the last 12 months, I think. Correct me if I'm wrong on the record. If Bean had access to earlier events, wouldn't his testimony have been at least potentially much stronger?
Potentially, but that's not the standard that we use in determining whether harmless error should apply.
Was there prejudice? I mean, frankly, I'm at 403 balancing on this case, and maybe I'm shortcutting it, but I'm telling you all candor, that's one of the things that I'm kind of worried about. On the one hand, we don't want to stigmatize somebody just because they've had mental health treatment or have had some kind of diagnosis in the past. We don't want some jury to think, well, she's not deserving, and therefore the guy's not guilty of a crime. I mean, I'm sensitive at least to that notion. On the other hand, if the defense is that this was a suicide and there's a degree of support in the record for it, being is that, shouldn't the defendant have access to the kind of medical records that would significantly buttress the defense that he made at trial?
So I have 2 responses to that. The first is that the defendant wholly relied on these outdated medical records to establish the victim's state of mind at the night that she died.
The word outdated, that's where I'm getting at.
Okay.
But who says they're outdated other than you? Where's the evidence that no expert got to comment on that?
So I think the case law supports that 2 to 3 years in the past can be considered outdated for the terms of, in these types of cases. I mean, you can see that, those are the Kansas line of cases, and there are other courts that hold the same thing, that 2 or 3 years in the past makes it no longer relevant to a person's state of mind. And what I'm trying to get at with that is that the defendant at trial did not put on any evidence that the victim was depressed or suicidal at all in the days leading up to her death, the weeks leading up to her death, or the months leading up to her death that might have tied these older records to her current state of mind. There's no evidence in the record that she was suicidal at all close in time.
Counsel, getting back to your prior argument, though, that maybe we instead should look for patterns, what if the older records showed a pattern of the victim doing very well and then suddenly doing very poorly?
I think that could be a reason why, but in this particular case, I've read the records and I don't think that there was any support
But
for
how
the
do we
idea of that.
know? I mean, how does the defendant know that if they haven't seen those older records?
They have seen those older records. They got all of those records.
But the expert wasn't allowed to look beyond 1 year, and that's who they would rely on to give such an opinion, wouldn't they?
That's true. The expert did not get more than a year.
I also want to talk about the victim's age. She's 21.
Correct. So
So go back 3 years. My goodness, I think we all know people that age. And if your argument was this 45-year-old lady, the defendant is alleging that she committed suicide, and her prior suicide attempts were when she was 18, wouldn't your argument be much more powerful than a 21-year-old versus when she was 18?
I mean, the greater of passage of time is always going to be more powerful in terms of, if you're looking at 30 years.
That's my
versus-
point. 3 years doesn't seem to be very long in the life of a 21-year-old.
I mean, since their life is shorter, it probably is more significant than 3 years in the life of a 40-year-old. But, I mean, of course, the passage of time, I mean, if she was 18 and she was 45 when she got murdered, I mean, I think we would all agree that those were no longer relevant if there was no more evidence of the fact that, that had continued on into the future. Thank you.
Thank you. Mr. Fautsch?
Good morning. May it please the court. Trials like the one that Mr. Buelow faced are the reason that innocent people end up in jail and the reason that the public loses trust in our criminal justice system. At the heart of this appeal is whether or not we can trust the justice that was meted out in the Dubuque County Courthouse. This is a murder case where the defense is suicide. It's the only defense. Placed in front of you are 2 pages from Court's Exhibit C in the confidential appendix. I've highlighted portions where the decedent declared her intent to commit suicide, the number of times she had attempted suicide in the past, and the means by which she would commit suicide. Her stated means especially match Mr. Buelow's description of what happened that evening. She would grab whatever she could find. The jury was flatly forbidden from knowing any of this. The defendant's expert psychiatrist was forbidden from knowing any of this. His testimony, I agree with counsel, you ought to read it. It's incredibly stilted and it leads us away from the truth. When we should have been having a trial that is a search for the truth, we had the opposite. The jury was led to believe that she took a few antidepressants and that was it, when we know that the truth was something different. It's not just that these statements, of course, are powerful evidence for a jury to hear, but it's her entire course of treatment. We've talked about the means of some of her statements in the past, but we're also talking about how significant her diagnoses were. We're talking about bipolar disorder and borderline personality disorder, disorders that are extraordinarily serious, increase a person's ability to act impulsively, not necessarily a pattern, but the diagnosis itself is one of impulsivity tending towards suicidality. So this is the sort of thing that the jury isn't allowed to hear. One of the most striking aspects of this case is how far the state has separated itself from the district court's opinion and how they are in contortions trying to undermine the Court of Appeals' opinion. The state is not attempting to defend that these records were kept out on the hearsay rule as well, of course. The state has abandoned the character evidence analysis. The only case cited by the district court in its written order excluding these records was State versus Jacoby, and the state doesn't even cite it in its papers because it's plainly inapposite. Now, I would take issue that the district court doesn't actually appear to have done a Rule 403 balancing test. You'll recall that the written order excluding these records, the court says, the parties asked me to write down what my ruling was because they said they didn't understand it. And in that order, Judge Zrini-Wittig says, I'm relying on State versus Jacoby. This is what I'm doing here. I think it is absurd for us to come here and say, well, we can balance this prejudice versus probative nature of this because the judge in another written order said that these records were exculpatory. Once we're dealing with exculpatory records, we are now in a world where we're thinking about the 403 balancing and test, and we're asking, is it a waste of time? Is it extraordinarily substantially prejudicial? Is it harassing? And there's nothing in the record to think that that's what was going on here. What we're trying to do.
Ask you a factual question. You can get to it much quicker than me, and then it will help me in my process here. What date was the death?
The death was March 30th, 2017.
And the court allowed the defense to go back 1 year in records for the expert?
The defense had access to records going back quite a long time, many years, including her involuntary commitment at the University of Wisconsin-Madison. The expert was only allowed to review 1 year's worth of records, and he was specifically precluded. You'll see that there was a question asked and testimony that was objected to and sustained, just saying, well, what do you take this medication for? The implication being that she might take the medication for one of the various diagnoses that she had. It's sustained, and the expert is not allowed to discuss even what's in those records for that 1 year. It's merely that he's allowed to see them.
Notice the first page. It looks like the admit date is April 1st of 16, would be almost exactly 13 months before she passed away. Is that correct?
Right.
This document you're saying was not allowed to go before the jury?
So the document never goes before the jury.
Expert, was he allowed to even look at this document because it was 1 month beyond 1 year? So it was 13 months away from her death, and the court restricted it to 12 months?
That's my understanding of the record. And just so we're clear on the documents that we're looking at, Your Honor, the very first page of this document goes back more than a year. This other document goes back until 2015. And I think it's really, it's a dangerous precedent that the state would like to set by conflating this idea of temporal analysis and the character evidence rule. I want to be clear that the Court of Appeals did not apply a temporal analysis to the character evidence rule. It's actually the state that's trying to do that. That's not what happened. The Court of Appeals said, for determining whether evidence is something of a blameworthy or praiseworthy character trait, something that would fall under the character evidence rule, we're not looking at time. And of course that makes sense, because if it's evidence tending to show that somebody's a bad person, it tends to show that whether it's 30 years old or 1 day old. And so the Court of Appeals says, no, state, we're rejecting your test where we use some sort of temporal analysis to determine what is and is not character evidence. Temporal analysis is just fine in the context of Rule 403 balancing, and the Court of Appeals opinion doesn't say anything contrary to that. What the Court of Appeals opinion does is it rejects as a factual basis that these records are too old, or that they would not have been valuable to a psychiatrist analyzing this case, or that it wouldn't have been valuable to a juror hearing this case.
Given the nature of the district court's ruling, what is the standard of review that we're to apply? And are we going to do some of this analysis in the first instance rather than actually reviewing a decision that was actually made?
The standard of review is abuse of discretion for an evidentiary analysis like this, but of course it's a mistake of, she makes a mistake of law when deciding what rule to apply to the admission of the evidence. So the fact that she made a mistake of law means that it's an abuse of discretion.
Counsel, what are we to make of the prejudice argument that the state makes? That the nature of this injury, it's multiple stab wounds, there's apparently an admission, perhaps, as the defendant walks out of his house. What are we to make of those?
Well, I'll put it, there's multiple answers to that. It sort of goes to the harmless error instance, and it goes to the prejudice argument. So first, just for prejudice. I think the state sets us off on the wrong foot by arguing that you can't be that there's a problem that you may not be a good person if you have mental illness, and that's why we have to keep these sort of records out, that's the prejudice that might be there. And I think modern science and modern courts have thoroughly rejected that notion that you can't be a good person and still have mental illness. So that goes to the prejudice piece. The harmless error piece is related to that. So on the harmless error analysis, you have to ask yourselves, as I said when we started this argument, we have to ask ourselves if we can trust the justice that was meted out in Dubuque County. And you have to look at the totality of the circumstances for that. So we can start just by talking about the evidence at the scene. The state's expert agrees that Mr. Buelow may have been as much as 10 feet away from him, away from Miss Link at the time that she was stabbed. The state's expert also agrees that the 2 stab wounds were not instantly fatal and they could have both been self-inflicted. They leave that possibility open. And of course, Mr. Buelow's own expert says that the stab wounds are more consistent with self-inflicted wounds than they are with Mr. Buelow having been the one who stabbed her, because the stab wounds on her hand are consistent with putting it into her chest and the knife sliding. It's a butcher knife and has a sharp end. And so we had an actual live fact dispute based on just the evidence at the scene, okay?
Counsel, if you don't mind, I want to direct you back to the prejudice question and pose it this way. There's a huge stigma in our society on mental health, I think. I mean, I kind of take judicial notice of that. You can kind of push back if you think I'm over the edge. But there's a risk when you use mental health records that a fact finder will decide that the victim is somehow less than worthy. Trials and morality plays. There's a risk that someone would say, well, this mental health stuff, I don't like people with mental health, or the life is less worthy, or she's less trustworthy, or et cetera, et cetera. Isn't that an issue we got to at least think about in this case?
Justice Apple, I think you're right to make that observation. Of course, there is stigma associated with mental health. But we can work around that by watching the arguments of counsel, by watching what is said of witnesses, by giving admonitions. There's all sorts of reasons that we can deal with the stigmas that people bring in to our courtrooms. That's not a reason for us to pull back on our search for truth. In fact, we cited the Wigmore treatise about this, where they said that modern courts in viewing this evidence have sort of pulled back from the search of truth to the extent that we're talking about the Secant decision or that sort of thing. And Wigmore actually encourages us to be brave in our search for truth. And so despite there being the potential for a stigma, that's not a reason for us to not vigorously search for the truth. And of course, I don't think there's anything you would see from counsel for Mr. Buelow at trial or his experts or his or what he says when he testifies. This is a tragedy, but there's no reason to compound that tragedy with having a search for the truth that's a sham.
If we order a new trial in this case, are we undermining the constitutional and statutory protections for mental health records that all Iowans should have?
And the state is simply wrong to tie this back to 622.10. 622.10 is an exclusionary statute, right? It says there's this privilege for the psychiatrist patient, just like there are for others. There is an exception to that, and that exception is narrow, and it's what we have in this case for exculpatory evidence. It is frankly disingenuous, and it's troubling that the state would argue that because of this decision, they would get to talk about the alcoholism of a drunk driving defendant or anything along those lines, because the statute only permits exculpatory evidence, that the state would try to use this as a way of arguing that, gosh, we might try to use inculpatory evidence against a defendant to try to blow through the privilege for that is absurd. And so I would urge this court to simply, counsel for the state started this off as simply saying, look, 622.10 didn't give us a way of how to deal with these records for admission. And that's right. I agree 100% with that. The way we deal with the records for admission, once they've been turned over to the defendant per 622.10, is the rules of evidence. It's nothing different than what our courts are accustomed to doing. We shouldn't be treating these records any differently than the rules of evidence would dictate that we do. I think that's what the legislature must have intended when they didn't tell us to treat the records differently. I will briefly end by talking about the harmless error argument and something that, at least with this case, what brought us to this case initially is that when you look at what happened in this courtroom, with a holdout juror removed during deliberations, with an alternate brought in, with a note by a judge being shredded, with no investigation about whether or not that holdout juror should have was actually deliberating, what we're talking about is, I think, the sort of justice that should turn our stomachs. And so when we talk about harmless error, I think you also have to look at the procedural deficiencies in this case. This was a mistrial until the judge did something that she had absolutely no business doing. The sort of thing, when I said that this case undermines the public's conception of fair justice, it's the opposite of 12 angry men, right? Instead of the one person who's the holdout and might be able to convince the other jurors or create a mistrial, that person is kicked out, and then he's convicted. I don't think that that comports with any sort of notion of how we want Iowa courts to behave. Thank you.
I'm going to start right off the bat with a question. And I'm following up from what I was asking earlier. Correct me if I'm wrong, but the district court judge made a ruling for 1 year. And this document, these statements made in this document, which I'm not going to repeat, is 13 months out. Is that right?
I thought that, I don't have the document in front of me, so I can't remember what exactly the date is on it.
Let's say I'm correct. Let's say on top it says admit date is 4/1/16, and I believe she died, actually in 3 of 7, 11 months.
Right, so I think it's
It was
within,
included?
I thought that this expert got that record, because I thought it was within the year.
The expert got the record, but the record was not allowed into evidence, and
Correct.
the expert could not talk about that, correct?
That's correct, yes.
So doesn't that does the 1 month seem like an arbitrary number, or the 1 year, excuse me? Is there any method to that madness when there's more evidence beyond 1 year? Can you explain how it was not an abuse of discretion to just pick 1 year instead of maybe actually looking at the records and finding out how far back her history went?
Well, I believe the district court did look at all of the records. And so, based on her review of the records, she determined that the year's worth of records would be the only ones that could possibly be relevant to the victim's state of mind when she died. So I believe that's why the district court limited it to the year. And I also wanted to just mention, it's a case I read when I wrote my application for further review, but I realized I did not cite it. So I want to give you the site. It's a Vermont Supreme Court case called State v. Buelow. It's 95 A 3rd 460. And it's from this case and a few others that are cited in that case from Louisiana and other states that talk about when you make a categorical determination that a person's mental health records can never be excluded by the character evidence rules, that allows the state to use the information of defendants' mental health records against them at a criminal trial. So I just wanted to let you know that that's not an idea I created out of whole cloth, that exists in other states, that these records are able to be used against a defendant at a criminal trial if they have a mental health diagnosis, when you completely eliminate the character evidence rules to their application. And I actually think Buelow is a really interesting case and worth some time looking at it from this court, because in that case, they did determine that the character evidence rules shouldn't apply to mental health records. But they recognized that 403 might be the linchpin in making the determination about when these records should come into evidence. And that's because they determined that it was sort of anomalous, that we wouldn't allow, the state to put on evidence that the defendant had a reputation as a thief. But we would allow them to put on, evidence that he was a kleptomaniac. And so, we have to recognize that the character evidence rules should apply in some ways, because the line, as they say in that case, between character and mental health is often very blurry. And so we need to have that recognition when we make a determination about whether or not these records should be admitted.
Can you address briefly the harmless error issue and specifically counsel's statement earlier that there was some physical evidence that supported a theory of the suicide defense?
I would push back on that a little bit and just say that our medical examiner determined that based on all of the physical evidence that it was a homicide. He did acknowledge at trial that there was some possibility that these could be a self-inflicted wounds. But he determined that based on their orientation that he did not believe that that was the case. But that determination is only on the physical evidence of the entry of the wounds. It's not a determination of all the other physical evidence that was put on at trial, which is that, one, we have a victim who was clearly severely beaten up before she died. She had multiple bruises all over her face and body when she was beaten up before she died. Second of all, it's true also that our blood spatter expert said that it's possible for blood spatter to travel 10 feet. He didn't give an exact number, but it's possible for it to travel some way through the air. And that the defendant uses that to support the idea that he was standing away from her body. But his testimony was that he was standing in a doorway when she was killed, and that the blood spatter on his shirt was from standing in this doorway. But this doorway had no blood on it. The tiles in front of the door, no blood on it.
Wouldn't that be a great argument to the jury as far as, weight of the evidence? And I want to get back to the mental health records. Even with the mental health records in, wouldn't you have made that argument?
They did make that argument. That argument was made.
Right. But my point is, the records, does that argument in any way diminish the defense that the defendant's trying to bring up, that there might be a connection?
I don't think so, because if you look at the academic research and the case law and the treatises when it comes to whether or not this evidence should be admitted in the first place, one of the critical components is if the physical evidence is, it's quote, as suggestive as suicide as it is of homicide. And it's the state's position that that is not the case here, that the physical evidence of the scene does not support any possibility that this could have been a suicide, that it only supports a homicide. Especially, I also mentioned, that the knife was found significantly far away from the victim's body. There was also blood spatter on the back of defendant's shirt, which would also be impossible to get if he was standing in a doorway. So, you have to look at that information when making the determination about whether or not in this particular case a new trial is necessary. And the state would submit in this case, it's not, because the physical evidence doesn't support the idea that the victim committed suicide. Thank you.
Thank you. Case has been submitted, and we will adjourn court at this time.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.